Welcome back to the second episode of the Lawyer Joe Show. With me always is producer Tommy in the back, and of course, the star of the show, Joe Ahmad. Joe, how's it going?
Good. How are you?
I'm doing well, Joe. It's 2026. Happy New Year.
Happy New Year.
How do you start your year typically? Do you have resolutions? Do you set goals? Someone of your stature with kind of the life you've lived so far. I'm very curious, and our audience might be curious of, how you typically kind of look into the new year.
Well, I think the first thing I do is start from the point of I have no stature. I think you have to come into the world of, each and every day, start your day, you're entitled to nothing, right? You have no stature. And so as a result, no, I don't do resolutions, but I have one overarching thought is I need to learn more. I always need to learn more. And even at my age, I have a lot to learn. And I think you have to have that attitude. And so this year, hopefully, brings more learning for me. I remember when I graduated from college back in 1984, right? And, I thought, okay, I've been a student all my life. I'm kind of ready, right? I'm ready to go out there and do things. And, the president of Lawrence University, where I graduated from, tells the whole class, congratulations, you are now ready to learn. I was like, what have I been doing all these years if I'm just, he mentioned that you're going to have to learn because the world will change a lot over the coming years. And I thought this was crazy. But as I've seen, he turned out to be 100% correct. The world has changed dramatically from when I graduated in 1984. I think, people can understand that. I think only if you lived in that area, you really appreciate how much it's changed. But as a result, you are always learning. And even if the world hasn't changed, the transition from student to professional is a huge change. And the nature of this work, probably all work, is you are always learning. And if you are not learning, you are regressing. So I start every year out, with a plan of more learning. I spend a lot of time trying to educate myself in a variety of different aspects.
No, totally. I really appreciate that. And part of hopefully this year, you'll learn a lot about this space that we're in social media. And
one thing I'm learning about.
Yeah, right. Yeah. I mean, that's something I caught on early with you, and I really do appreciate is that, this graduating in 1984, right, to 2026, the social media and the media landscape has probably changed a lot.
Well, we didn't have social media.
Exactly,
Yeah.
right? And, your willingness to lean into this and try to kind of better understand it and kind of present yourself and kind of find your place within this new landscape where the information is shared is super exciting. And we're excited to be a part of that journey with you. So, speaking of that transitioning and learning as a professional, I want to start kind of asking you some questions that pertain to your profession in law. In the year of 2026, Joe, who should actually go to law school and who probably shouldn't?
Well, actually, I don't think this has changed.
Okay.
I think the only people that should go to law school, and this may sound silly, but is people that really want to be lawyers. And I think, unfortunately, today and over the last many years, even when I graduated, I see, classmates are like, I've got a history major. I'm a poli-sci major. What else am I going to do? And I'm like, that's not a good reason to go to law school. There are actually a lot of different things you can do with a college degree, but no one should be like, there's no other choice for me but to go to law school. You go to law school because you really want to be a lawyer. Because if you don't really want to be a lawyer, you're going to find out that it's a pretty tough grind. There's a lot of tough things about the legal profession. Looking, just at litigation, for example, right? And I don't think this aspect's a lot different for other aspects of the law, but the work schedule can be brutal, right? I mean, this is not a 9-to-5 job. If you're in litigation, a lot of times your schedule is not your own. You can plan a vacation, but your plans can go awry real quickly depending on what a court or a client will do. And, not to mention the huge amount of stress that is in the legal profession, particularly in litigation. I don't think it's a secret that a lot of lawyers have addiction issues.
Mm.
And I think a large part of that is, from the stress, the pressure, in litigation, the fact that you go from probably graduating from law school and doing well in, virtually all of your classes, probably not receiving a lot of failing grades. And then you go into a profession where, you may get an adverse result in trial that may feel like a failure. And that is difficult for people to deal with. And so, as a result of all the negatives that can exist in the legal field, the only way to overcome that is if this is something you really want to do. If it is not, it's going to feel terrible. And that's why I think we have a lot of burnout in the profession. Because if you are going into the job simply because you have no other choice, or because, well, lawyers make a lot of money, well, you're likely to find out that, well, first of all, not all lawyers make a lot of money. Number two, it can be so brutal that you don't actually enjoy your life. So that is that is my only advice for people who should go to law school is, do you really want to do it? The other thing I will say, though, is, are you going to be a good lawyer? Because obviously it enhances the whole experience
Of course.
if you're good at what you do. What kind of a law school are you going to get in to? Are you going to go to an elite law school, a kind of middle tier law school, a lower tier law school? It can affect your job prospects, right? So you've got to be kind of honest with yourself, right? And look, a lot of middle tier, even lower tier law schools can give you a great legal education, but they might not give you the same job. And if your if your thought is, well, I want to be an M&A lawyer in New York, and make a ton of money, then you better plan on going to an elite law school in all likelihood. So you kind of have to know where you are if you have certain job expectations. But regardless, if you don't really want to do it, it's not for you.
That's very interesting. I read an article, Joe, that there are pretty interesting signs of recessions back in 2008, which were defaults and delays on car loans, and another was an increase of applications to law school and to graduate school. And that's been happening more recently because of the tough times that we've been in. So that there's an increase in LSAT, an increase in applications to law school, because there's an assumption that if I go to law school, I'll make money, and they're driven by that assumption. So you're saying that if you're money hungry or if you're only focused on that it might not work out for you?
Oh, absolutely, right. And I'll say two things about that. Number one, there are, and we all know this, there are way too many lawyers in this country. But by the same token, there's not enough good lawyers. And that has been the case forever, because I think we have a lot of people that go to law school, perhaps just for the money or for other reasons, and their heart's not in it, so they don't do well, and they become one of the excess lawyers. As opposed to, people will say, do what you're passionate about. Other people say, do what you're good at. There's a strong correlation in my mind. If you don't really want to do it, I don't think you're going to be very good at it. And by the same token, if you're passionate about it, you're pretty likely to become at least a decent lawyer, if you have reasonable intelligence. And so if you're passionate about it, then yes, I think you can become exactly what we need, which is one of the few good lawyers, hopefully great lawyers out there, because there's always a demand for them.
Awesome. A lot of students, Joe, they chase summer associate roles. What's the real difference between being a summer associate and becoming a full-time associate?
Well, I think you just, you have to look at the math. for the difference between being a summer associate and being an associate, right? Uh, the math on being a summer associate is that you are very likely to get a job offer after being a summer associate. I mean, the odds are overwhelmingly in your favor, and the bar is very low, right? A lot of times, as a summer associate, you don't get a whole lot of substantive assignments because law firms aren't necessarily grading you by the same grade as if you were an associate, right? A lot of times, they're really just trying to attract you as a summer associate into going with them. So there's a lot of social activities, there's a lot of fun. The assignments are usually pretty light, and you are highly likely to get an offer. So what does that mean? Well, basically, you really have to screw up in order not to get an offer sometimes. You either have to, really screw up an assignment or say something outrageous, just kind of do something that's out of the ordinary in a bad way. Now, you become an associate and the math changes. If you look at, most firms, especially big firms, if you look at how many people make partner in a given year as opposed to how many people started as an associate, right? The math is usually far less than 50%, right? So now it's changed from don't screw up to now you have to stand out in a good way. And a lot of that means, working long hours. Are you one of the ones that works the hardest? Are you going to bring more money into the firm than your peers, for example? And so, whereas it's easy to get a job from summer associate, it can be really tough to excel in the firm as a partner once you start as an associate.
Once someone does get that first job offer after law school or the bar, Joe, what are the most important things they should consider before accepting?
Well, the first thing is you want to invest in yourself. So you want to look at the firms that will give you the most training, the most experience, and kind of give you the most skills that will really propel your career 5, 10, 15 years down the road, right? I think a lot of people kind of look at it as, I graduated from elite law school, I got really good grades, I am set for life. No. Again, you're entitled to nothing. You are either advancing or you're going backwards. And so, 15 years out, do people care about the fact that you got great grades in elite law school? No, that's like saying I did very well in an elite junior high. I mean, it really is. And what people are interested down the road is what kind of skills do you have? Now, it can be a big firm that gives you those great skills. Look, I mean, if you go to a firm known for their merger and acquisition expertise and you're in that department, sure, you're looking like you have some skills that might be attractive to another firm in the event you don't make partner, or even if you do, right? You've got options. In litigation, it becomes a little more difficult, right? Because at a lot of big firms, you're not really getting the trial experience you need to have the skills in the event you need to find another job. So wherever you go, the most important thing in my mind is what kind of experience, what kind of skills will I get, in 5 years, 6 years, et cetera. Now, I get it. Today, most law school students are graduating with crushing debt. So money will play a role. But there is a way to get training and a good salary at the same time. There are firms that do both. I'd like to think our firm, AZA, does that. But there are firms that pay a lot but don't give a lot of training. And if you're solely looking at this as I'm going to go to a job that pays the most, and that's my criteria, I have to wonder about the logic of going to law school, taking on this massive debt for the sole purpose of finding a job that allows you to pay for law school to begin with. No, instead, go to the job that will give you the experience such that you will have a good career 10, 15 years down the road. Not one that allows you to make a lot of money for just a few years and then you fall off the map.
How can a young student who just graduated or an aspiring lawyer evaluate whether a firm will give them that experience prior to, walking through the door and getting the job?
So the first thing you can do is talk to the associates. Ask them specifics and get specifics, right? I mean, it's almost like cross-examination. Somebody will make a broad general statement and you ask for the specifics and you ask them to tell you exactly what they did, right? Because, I can tell now by looking at resumes, right? Because I see tons of resumes, and you can kind of tell the ones that they say worked on a case and got a good result or something like that. And I know you probably weren't, first of all, the case may not have even gone to trial, right? And if it did, you might not have been the lead lawyer or one of the lead lawyers. So that's a huge tell. But when you interview at a law firm, sure, you are trying to make a good impression, but probably more important than that, you're really there to find out, are you going to get the kind of training and experience you need? And the way to do that is to ask the associates. Ask them specifically what they are doing. So it should be relatively easy as long as you get an interview.
Yeah. So you mentioned what a broad generalization of worked on a case on a resume looks like. What is an ideal version of that on a resume that when you see stands out? Like, how would you like that to look?
Well, first of all, I'm talking about resumes from lateral lawyers, not
Correct.
those out of law school. We completely understand that people coming out of law school don't have trial experience.
Correct, yeah.
But if I
For a lateral lawyer, yeah.
Yeah, for a lateral lawyer, it's different. Now, I will say for somebody coming out of law school, what you are looking for is demonstrated interest in litigation or trial work. So how can you tell that? Well, I have opinions about, for example, mock trial, moot court, and the like, but we're looking at things like that just to show an interest, not for the reason, that I think a lot of people think, which is it shows that I'm good. Yeah, expertise.
Yeah.
No, I'm sorry.
Yeah.
It just doesn't give that. We have to educate you. We have to give you the training.
We're the experts.
Yeah. And frankly, we have to give you the experience.
Totally.
Because there's no experience like trying a real case.
Correct.
But it does show interest, and that's very important. Because like I said, if you're not really interested in it, you're not going to do very well, and you're going to hate your life. And frankly, we're not interested in that as a law firm, right? So, but looking at a lateral lawyer, we want to see people that have taken depositions, have argued to the court, that have, yes, tried cases, and ideally tried cases from a first chair perspective. And since we do, complex commercial litigation, we'd ideally like to see that in those type of cases. Doing so in other types of cases, for example, personal injury, sure, it's great because you've got real trial experience. It's not as applicable to us. Still valuable, still may be, depending on where you are in your career, something that puts you ahead of the pack. But that's the ideal. Somebody with, that has the experience of taking depositions, arguing at hearings, and trying cases in complex commercial litigation. Not something you're going to see from lateral hires with only a few years experience, but at a certain level, yes, you expect it.
Very interesting. So getting back to the fresh new lawyer out of law school, what's the shift really like from being a law student to a practicing lawyer? What surprises most new lawyers?
Well, I don't know if it surprises them, but I will say I think a lot of people have a tough transition from student to professional, and there's a whale of difference.
Hmm.
And so if you're looking at this as a continuation of school, you're looking at it clearly the wrong way. And you can kind of tell those people. I mean, first of all, everything that they did before as a student remains the same, right? And this is a different world. The professional world, I'm sorry, and this doesn't apply just to trial
Correct.
work or to litigation or
Every
even to
job.
being a lawyer,
Yeah.
but, you know, some people come right into the job and they still look like a student. And I'm
Hmm.
sorry, ditch the backpack, okay? I'm not saying you will never make partner as a backpack, but come in at least and look like a professional. And that means dress well.
Hmm.
Now look, I'm a little bit old fashioned when it comes to dress. If you can't tell, my, casual day Friday is a sport jacket and slacks.
Nice.
But still, you should look like a professional and not a student. Get a briefcase or a professional looking bag, dress well. And by the way, if you have any doubts about how you should dress, because look, I get it. If you're taking a job as a lawyer in a tech company, it probably looks a little different than coming to work at a New York law firm. But look at how the junior partners, or even better, look at how the senior associates dress and carry themselves, because those are the ones that are trying to make partners. And those are the ones that you can emulate,
Hmm.
right? And should be emulating. Also, they can give you some of the best advice about how to handle yourself. The other thing is, remember, you come from a law school, and most people are, they're interested in kind of fitting in within their peers, right? Well, now, you've really got to form relationships with, older lawyers,
Hmm.
right? Whether it's the partners or even the senior rather associates, it will be important to form relationships with them. And so being the cool kid in law school, is not going to carry you very far. You're not there to be the cool kid among your peers. You're there to be a good professional. And that is a very different world than I think some students are used to. And therefore, some of them handle the transition very well. And others, I think, struggle to make that transition. And I think that's why, frankly, you can't always say, to somebody coming out with great grades from an elite law school that you are going to make it at a law firm, because it is so different. And you need to be able to be successful. Yes, sure, you had to be a great student to get the job, but now to advance your career, you're going to have other skills.
Makes a lot of sense. A question came to my mind just listening to you speak. Does a law firm evaluate like a student who's top of their class from like a mid-tier law school stronger than someone who's like middle of the pack from an elite school, or what has more weight, or does any of that matter?
I think it varies from law firm to law firm, right? I think some will value the elite law schools and weigh it so heavily that they will take a mid-tier student from an elite law school and favor that student above somebody that graduates from a lower law school. And so, my personal view is there are good lawyers coming out of virtually every law school. It's just the percentage of the class that is going to be good lawyers. It goes way down as you go down in the tiers. But I can tell you from practical experience and just seeing it, right? You can take the most elite law schools, and there are bad lawyers graduating from them, and vice versa with the lower tier law schools. So again, there are no guarantees. Your law school degree, no matter where you graduated from, is no guarantee of success. And so, like I said, it will vary depending on, the law firm, especially if, some of the law firm partners went to a certain law school. In our case, we have a lot of, preference for the University of Michigan, but, realistically, we're hiring from a number of different law schools.
That makes a lot of sense. Joe, you've written about this on your blog, but why is there truly no off the clock for executives? And does that mindset apply to young lawyers too?
Well, because executives and especially those at larger companies are really in the public spotlight. And, it's not just they're in the public spotlight, it's they're the ones when you're in litigation, who are you mainly dealing with as witnesses? Well, it typically is a lot of the executives. And so their behavior is under the microscope. It can be under the microscope in a boardroom, it can be under the microscope in the public, and it can be under the microscope in litigation. And so the difficulty, I think, is that a lot of executives really aren't used to being questioned. Maybe during board meetings, but generally speaking, on a day in and day out basis, they're the ones asking the questions and getting the answers. They're not being questioned. So, to see their behavior being questioned in a public setting or in litigation is a little bit of a new experience. But as we have seen, various, unfortunate incidents that have, become, a matter of public record where executives have engaged in, maybe unrelated to their work, but what I'll call bad conduct. At least the public thinks so. And, the reality is that you lose a lot of anonymity that you have as a lower level employee because the public, in large part, doesn't care about their transgressions like they do about an executive. An executive is the public face of the company. And the same is true in litigation, right? When the CEO is testifying, it is viewed very differently than when a lower level employee is testifying. And they kind of have to understand that, they are always on display as opposed to others that have more anonymity.
And when an executive is off the clock and a mistake is made or, they cause some kind of issue for themselves that's unrelated to their profession or work, what is that process like when they come to you for representation? Like where do you begin to kind of help and resolve the situation?
Well, it depends on what the issue is, right? If you see in a case where they have done something wrong, you look at it from a case standpoint. If they're individually looking for advice, then you're looking at how to get them out of a pickle, so to speak. The one thing that I can tell you is, the old saying, the cover-up is what gets you in trouble, right? I think that's probably the number one advice is, when you have, when you're in a hole, the other saying is stop digging, right? Don't make it worse. And the easiest way to make it worse is to engage in a cover-up, right? So whether it's litigation or otherwise, you've got to come clean, and you've got to come clean fast. That is, in my mind, the only way to deal with it.
That was great. Okay, Joe, we all send hundreds of emails. Can those emails actually get you or your client sued? And what are the most common email mistakes or evidence that shows up in trials?
Well, I think the mistake is, look, we all send, I can send 100 emails a day, right? And so we have this kind of casual attitude towards emails. And the vast majority, 99.99%, right, never see the light of day beyond their intended audience, okay? But, of course, as you might imagine, It's the really bad email. That's, it's unfortunate you get judged by your worst acts. Well, you get judged by your worst emails, because those are the ones that tend to see the light of day. You cannot have a casual attitude towards your email. Um, and the other thing you need to know is emails are easily discoverable, right? I mean, there is a record of the email. Anytime you send an email, by the way, on a company server, you can expect that that is, for as long as that is on the company server, that is something that can be discovered in litigation.
So even if I trash it and delete the email.
Yeah, a lot of times when you delete it, it's not really deleted, right? It will be on a company server. It could be in the recipient's hands, whoever you sent it to. So I think the best way to view it is anytime you send an email, don't send one that you are afraid if it ever gets the light of day. You have to be thinking of it as, if I send an email, is this something I'm comfortable, with being public, right? So I don't know that a lot of people really think that way, and I understand, because if you're not a lawyer and you don't see bad emails, really bad emails show up in litigation, you're probably not thinking that way. And we tend to see, the bad emails, right? And sometimes as a lawyer for a client, when they send out, bad emails, we're, moaning and groaning about that. But maybe I should be thankful it creates a job for me. But, from a client perspective, they should be more careful.
Yeah, it's interesting because it's become a lot more easy and accessible to draft and send, right? It's as simple as sending a text now with this smartphone, so I can understand how people can write them off as like a casual exchange of information. So is this common that you come across these type of issues via the email communication?
Well, yes. And I think, that's one thing that's very important, right? Before we had emails, we wrote letters. And letters were an arduous process. And so much more thinking went behind a letter than ever goes behind an email that I can send, from my couch while watching TV, on my, Apple iPhone,
Mm-hmm.
right? And so it's, unfortunately, sending emails, and texts is just far too easy, and it's far too easy to do without even thinking than used to be the case when we wrote letters. I don't know if anybody actually does that anymore, by the way. And most of the signatures that I do aren't actually on letters anymore; they're on checks.
Yeah.
And even those are starting to disappear. But
No, it's all e-sign.
but in any event, yeah, I mean, look, the advance in technology is great, but unfortunately, the side effect of it is we have gotten sloppy about the things that we send out.
That's a fire clip. Joe, for associates who want to try cases, what are the concrete things they can do early in their career to position themselves to become real trial lawyers?
Well, first, let's start, from law school or even before. I'm a big fan of theater. I did it myself, or at least I was forced to do it. But it's great experience, and maybe not for the reason people think. They think that lawyers are up there acting, and therefore this helps you act. And I think that's dead wrong. You don't want to act. You want to be yourself. But I think it does help you be yourself in the sense of it gives you a comfort from a platform where you're talking to an audience, because that is what you are doing as a trial lawyer. You have to have that comfort. You cannot be yourself when you are uncomfortable, when you are scared out of your mind. And theater helps you get past that. The other thing is, if you're a really good actor, you understand the perspective of others, right? Because as an actor, you have to put yourself in the place, in the mind of another person. And from a jury perspective, this is critical because a lot of these people come in with a whole bunch of different perspectives. And if you're used to hanging out in a tight circle of people that all think the same, they are all from the same educational background as you, same cultural background as you, you're not getting those perspectives. And I like to think acting opens up yourself to at least thinking about other people's perspectives. So I think it's, theater is great. Other things that people do, they do mock trials. And look, again, I think it's a helpful exercise, but not necessarily for the reasons people think. It doesn't necessarily equate to a real trial. I mean, the difference between, a mock trial and a real trial is pretty significant. I remember the first trial lawyer, at least the senior partner at the first trial firm I worked with, Miller, Bristow and Brown, Dick Miller, and he was talking about the difference between first chair and second chair. He said it was like the difference between having lunch and throwing up. I can only imagine what he would have thought about, a mock trial and a real trial, right? They didn't do as many of them back, then when he was trying cases. But mock jurors do not think like real jurors. And the reality is, mock trials, when the stakes aren't the same, you're not thinking the same way. However, it is a good exercise to go through. Again, I think it gives you more comfort in kind of that mock setting of a trial. It gives you a little bit more confidence, right? And at least you are participating in the strategy and the examinations that you would go through at trial. So yes, it's limited, but I still think it's a little bit helpful. And even moot court, which doesn't necessarily have the same exercise as a mock trial. Again, you are speaking in front of an audience. Now, it may be, other lawyers or law professors or what have you, but at least you are arguing. And I think anything that gets you on your feet talking to a critical audience can be helpful. Now, as a lawyer, then I think you need to, number one, try cases, obviously. Short of that, go out and watch good trial lawyers try cases. Good trial lawyers. Because the reality is, if you go down to the courthouse most of the time, and maybe this is a confidence builder, but you will see a lot of lawyers that are not necessarily great trying cases. You want to go see good trial lawyers. Read trial advocacy books. You'll find that they don't always agree, but that's fine. I think you'll gain a lot of information, not as much as trying a case, but short of that, I think it's very helpful.
What is the difference from I'd like to hear from you between being first chair and being second chair?
Well, I think it all changes, right, when all the weight and responsibility of the trial are on you. You're the one ultimately responsible for making decisions. You're the one ultimately responsible for coming up with the strategy, for the theme, for the trial assignments. And so it's a huge difference, right? I mean, I can tell you from trying cases as a junior lawyer, perhaps as, second chair on some bigger cases, that you just don't go through the same exercise in your mind. When you're first chair, you're probably thinking about that case in your sleep, right? I mean, the weight of the responsibility is immense. And so, yeah, it's a very different exercise. I understand you have to start somewhere, but until you've experienced being the one responsible, you probably don't fully understand what it's like to have that weight.
Like Dick Miller said, it's the difference between eating a sandwich and throwing up. Huh?
Exactly. I found that he was right after my first chair experience.
Joe, losing a case can hit very hard. How do you personally bounce back and actually build real confidence after a loss?
Well, number one, understand that this is part of the process, right? This is not like school where, if you got an F, that would be a disaster. So stop looking at a trial loss as an F, as a failure. Start looking at it as, kind of an advancement along the path, along the journey, right? It is part of the process. And understand that there's an opportunity that comes from a loss. There's a great learning opportunity. The reality is, in my experience, and I think most good trial lawyers' experience, you learn a lot more from your losses than you do from your wins, right? The setbacks is where you learn. So it is an unbelievable opportunity. It won't feel like that at the time, believe me. But it is an opportunity because you don't think as much after a win. You don't go back and think, well, what worked and what didn't, like you do after a loss. Unfortunately, the losses stick with you and the wins are fleeting, right? But because you're constantly thinking about what went wrong and you're analyzing that and you're improving. But understand, again, this is part of the process and this is a learning opportunity. And I think that can give you the confidence. And you should understand also that once you have taken a loss, the sting and negativity that you feel from a loss goes down a little bit each time, right? It doesn't become as big of a deal. So I think that all of that combined, if you have that attitude towards your losses, I think can actually give you extra confidence when you go into court.
I love that. Losses are lessons, right?
Yeah. I mean, I'd like to be the lawyer that's going up against somebody that proudly proclaims they've never lost because they're the ones that have a lot to lose, right? And they're the ones that's probably a little skittish about going forward in trial.
I love that.
So, yes.
Joe, juries, they respond to clarity. Can you give us a real example of simple language versus complex language in the court and how that impacts winning a jury?
Sure. I mean, I think the first thing is remember that you're not trying to impress the jury with how smart you are, right? You're not even trying to impress the jury on how good of a lawyer you are, right? Instead, you want to impress the jury that your case is good or your facts are better, not that you as an advocate are better. So get rid of the ego, get rid of the attitude that you need to impress the jury with your skill or your vocabulary. You certainly do want to impress, and I don't want to overlook this. You want to impress the jury with how prepared you are, but not how brilliant you are or how great of an orator you are or your vocabulary. So skip that. Number two, use real words that people use, right? Unfortunately, once we go through the legal training of law school and become a lawyer, we adopt a different vocabulary. And that is not the vocabulary that most people on the street and most jurors use, right? Skip all of those terms. If it is a foreign phrase, if it is a Latin phrase, chunk it, okay? Get rid of it. Jurors don't use words. But there are other words that people use once they become a lawyer. I mean, I see, and this happens to witnesses too, the phrase, I don't recall. Well, I can't think of the last time I actually heard somebody say that in a real conversation. What do you say? I don't know. I don't remember. So use words that people actually use, not just words that are only used in a courtroom, because they get in the way of clarity, but they also seem artificial. And that gets in the way, I think, of clear and honest communication. Short words that are on a third to at most fifth grade level. But if I need a law school education or even a college education or high school education to know what that word means, it's not a good word to use. Now, that may seem like you're playing down to the simplest element of the jury, but I look at it as, look, you're arguing to a diverse jury, and a jury that is diverse in many ways, educational level is certainly one of them. So you want to clearly communicate with as many of them as possible. But also, even for your most intelligent jurors, clear, simple words are effective with them too. You're never going to, well, you're certainly not going to offend anybody by using simple words, but you're always going to be able to communicate, no matter who your audience is, with simple words.